Vickie Hall, a senior real estate specialist with RE/MAX Professionals here in the Denver metro area. And I've been in real estate for 27 years and worked with many seniors and their families and helping them transition from their current home to their new home. And one thing that has become very obvious to me is that real estate decisions and legal decisions go hand in hand. So because of that, I have a very special guest with us today. Her name is Nicole Andrzejewski. Did I do that right?
That was good.
Okay. A lawyer with Meurer and Potter Law Firm here in the Denver metro area. And her specialty is elder law. And that means that she deals with any of the legal issues with seniors. And a lot of those legal issues overlap with real estate issues. For instance, power of attorney, a trust, a will, probate, estate planning, capital gains. That's always an interesting thing for everyone. And basically ways to protect your assets that you've spent a whole lifetime accumulating. And we're going to talk about 6 different questions. And I think this should be very informative. And hopefully it will prevent your family from making any costly mistakes. So thank you very much, Nicole, for joining us today.
Thank you for having me. It's an honor to be here.
Yeah, I think it will be fun to chat about all these different things. And I think the first question is basically, what is the basic documents, the basic legal documents that senior homeowners should have in place? Or if they don't have in place, they should come see you to get them in place.
Yes, absolutely. So it's important for everyone to have powers of attorneys and wills in place. Now, if you're a homeowner, also having a living trust in place is important if you hope to avoid probate. A lot of people think that a will avoids probate, but a will does have to go through probate in order to be administered. So if you're interested in avoiding probate, a homeowner should come see us about doing a living trust.
Okay, interesting. Okay, so living trust, a will.
And powers of attorney.
Powers of attorney. Anything else?
Those are the 3 main categories that it's important for each person to have, homeowner or not.
Okay, yeah, that makes sense. Now, I've run into some issues with my seniors with title issues. Specifically, I have couples where one of the seniors has died maybe 20 years ago, and they've never done anything with the title. And talk about that when someone dies, what should they not immediately, maybe within the next month, come and see you and do with you, and why?
Yeah, so we do a free consultation. So if they want to come in, if they're not a current client of ours already, we'll meet with them at no charge, and we'll review their current plan if they have one. And that includes their deeds for their home or multiple residences if they have them. If they own property as joint tenants, then affidavit of termination of joint tenancy needs to be recorded with the county along with the death certificate to take the decedent's name off of the property. If they own the property as tenants in common, then we may be looking at a probate administration.
Which will delay the transfer of the property.
Correct.
Okay, interesting. So how does downsizing or selling a home affect the senior both legally and financially?
Sure. So downsizing can be very beneficial for a homeowner because it can free up assets and also reduce costs. But there are a few things that a senior needs to be aware of. The first of which is capital gains tax consequences.
Yes.
So if they've owned the home for a long period of time, especially here in Colorado where our home values have grown so much of late, there may be tax consequences at the time of sale that they're not aware of.
So that has come up several times in that the seniors are reluctant to sell their house because they think they're going to have this big financial nut that they have to crack. What can you tell us about that?
Yeah, so with capital gains taxes, I guess I'll start by explaining what basis is.
Okay.
So basis is the value that you've purchased your property at, plus any additions that you've, plus any,
Improvements?
yes, plus any improvements that you've made to the property over the years.
Updated your kitchen, your bathroom, replaced the carpet.
Yes, exactly. So you can add all of that to your basis number. So that's our starting point when we determine capital gains taxes. So we subtract, for capital gains calculation, the sale price by the basis amount. And that difference is the gain. And that's the amount that an individual will be taxed on.
Okay, so let's talk specific numbers here. So an example might be a couple that bought their house for $200,000 20 years ago, and it's now worth $700,000. So they put, say, $75,000 into the house. So now their base is $275,000
That's correct.
minus the $700,000, so that's $425,000.
Right.
I did my math good. So tell me about that $425,000.
Yes, so that's the gain that would be taxed on. Now, for your primary residence, there is a capital gains exemption amount. So each individual gets $250,000 exemption to reduce the taxes that they're going to pay on that gain. So if your gain is $425,000, an individual would be able to reduce that number by $250,000, and that remaining amount would be how much they are taxed on. For a couple, you can double that number to $500,000. So in this specific example, if the gain is $425,000 for a couple with their $500,000 exemption, they wouldn't end up paying capital gains. But for an individual with only $250,000 exemption, they would end up paying capital gains at the sale. Which isn't the end of the world, right? It's a tax that just has to be paid, but it is something to be aware of prior to going into the transaction.
To try to figure out your net proceeds from the sale.
Right, so you can plan ahead.
So I've also run into someone that is selling their house a year after their spouse died. So what happens to that $250,000 or $500,000?
Yes, so the $250,000 exemption from the deceased spouse actually carries over for 2 years.
For 2 years.
Yep, so you're able to continue to use the full $500,000 exemption if you sell within that time frame. Otherwise, there's a half step up in basis on the property for the deceased spouse's value.
So I don't understand the half stepped up value. Can you tell me about that?
Yes. So to take it back a little bit, there's a full step up in basis when someone passes away. So that means your basis was $225,000 when you were living. When you pass away and pass the property down to your heirs, their basis increases all the way up to fair market value at death. So a basis goes from $225,000 to that $700,000 number.
So it's a way to escape capital gains.
Right, exactly.
So it behooves a senior maybe to not sell their house before they die?
Right. So if you can hold on to the property and pass it down to your heirs, it's better for tax purposes.
So we're not talking about practical purposes, though. Taxes are one thing, but if the senior has fallen and broken their hips, can no longer do stairs, that's the most important thing, is their living arrangement and how comfortable they are.
Right. And another option we tell a lot of our seniors they can look into is renting out their property so that they can hold it until death, but still move out into a more acceptable facility.
Oh, interesting. So, okay. So if they don't need the proceeds from the sale of the house, that would be a good way to proceed to your next property Maybe even you're going into assisted living or independent living, where you pay on a monthly basis.
Right.
So you would not need that big hunk. And then you could be a landlord or have your kids be the landlord.
Hire a rental company, definitely.
There you go. There you go. Okay, that makes good sense. So I've had some seniors tell me that their children want to be added to the title to help with the transfer of the property upon their death. What recommendation or information can you give us about that?
Yeah, so there are a few considerations when adding someone to title. So when you add someone to your home title, you are essentially gifting a portion of your home to that individual. And there can be gift tax consequences to that as well, either while you're living or after you've passed away for your heirs.
Okay, interesting.
The other thing to take into account when adding someone to the title of the property is that they become a shared owner of the home, right? So if your purpose is for them to receive the home after death, that may work. However, they are currently an owner, and if they have any creditor issues, that could impact the home.
Okay, interesting. So, say for instance, a lien could be put on the senior's home because of something the child has done.
Exactly, right, because they are an owner even though they're not using the home.
How does that affect the stepped-up basis when the parent dies?
Yeah, so when you gift property, it's a carryover in basis. So meaning instead of the full step up in basis that somebody receives when they inherit a property, when they are gifted a property, they receive your basis. So going back to our earlier example, if the value of the home is $700,000, but your basis is only $225,000, the person receiving the gift takes the basis of $225,000 versus the fully stepped up basis of $700,000.
Wow. So what's the advantage of having a child on the title?
I
don't see any advantage.
Right, we do not recommend that people do that. It's better to leave the property to that individual through your will or trust.
Okay. So they think that it's going to bypass probate or something by doing that. And it may, but it has some pretty serious financial consequences.
Right. It can impact you during your life, which is the last thing we want to have occur.
Yeah, that makes sense. I would not have thought of that. So, Nicole, what should families know before helping an elderly parent transfer title? What considerations should they take into account?
Yeah, so if that parent is currently eligible for this Colorado senior property tax exemption, selling the property and purchasing a new property could mean the loss of that tax advantage.
Okay, so that's where they get like a, 10, 20% discount on the property tax that they pay?
Right, exactly.
So, Nicole, I bet you that you've seen a lot of mistakes that seniors make with real estate. What's the most common mistake that you see them making?
Yeah, so most seniors don't realize that recording a beneficiary deed on their property can have consequences during their life. So the biggest red flag I make sure all of my clients understand with beneficiary deeds is that it disqualifies the individual from Medicaid.
Well, that's a big deal.
It can be.
Interesting. So if they sign a beneficiary deed to the grandson, then all of a sudden they may not qualify for Medicaid.
They will not qualify,
They
correct?
will not. It's not a might.
Right.
It's will not. Okay, so I encountered a beneficiary deed on a senior with someone that the family didn't know. They didn't even know who these people were. These people had just befriended
Wow.
the senior and was trying to cut out the rest of the family
Very
from
concerning.
inheriting it, but they found that before that person died, and they were able to rescind that somehow.
Yes, very good.
Those are some of the major things that you get involved in.
Absolutely. Yes, we can definitely help in that type of situation.
Okay.
Yeah.
I wasn't even aware of a beneficiary deed before this popped up on the title.
Yeah, we don't like to use them that often because they do have those different consequences that can come in to play. What we do prefer to do is a trust or a will which transfers the property. And a trust avoids probate, so there's no need for a beneficiary deed.
Okay, all right, that makes sense. So if it was just a beneficiary deed, that still has to go through probate?
It does not.
Okay, all right. For just that house?
Just
But
that one asset.
Other things may have to go through probate?
Exactly, yes.
Okay. What if a senior wants to age in place? What recommendations, safety and legally, would you recommend?
Yeah, so number one is putting trusted decision makers in place so that if something happens to you, they're able to step in and help in your shoes without any sort of conservatorship or guardianship being required. And that brings us back to powers of attorneys, will, and trust. So having your comprehensive estate plan in place while you're still able to is very important to allow those loved ones to help you.
Okay, that makes sense. I also had a transaction recently where the man's twin brother died suddenly at a fairly young age. And so he had written something on a piece of paper saying, I want everything to go to my twin brother, and dated it. But when they went in front of, I don't know, the probate judge, the probate judge says, I don't know, anyone could have written that. So they had to get conservatorship, maybe? They had to be appointed.
So perhaps a special administrator was appointed in that case?
Oh, I know what it was. The judge had to supervise everything that was being done before he kind of felt comfortable that that's really what the deceased homeowner would have wanted.
Yeah.
And that took them a long time. That took them 6 months or so before they were able to do anything with the property.
Yeah.
And then these poor people, they were receiving all the bills to his house, and they didn't know what sort of assets he had or what bills he owed. And the only way they could figure it out is by what bills were coming to the house.
Right.
So that's
It
another
can be very
reason
difficult.
to have all those documents in place.
Right. And probate in Colorado isn't the worst thing. However, it is public. It's a minimum of 6 months. It usually takes over a year. And it does allow for creditors to come forward and make claims against the estate. So in a probate situation, it often takes longer to transfer any property, but especially a home. Whereas with a living trust, when you avoid probate, the successor trustee is more easily able to transfer the property at a quicker pace.
Okay, interesting. So I had another sale recently where the son had inherited the house, and they weren't sure whether an ex-husband was going to come in there and try to put a claim in. So they waited till they were past the year from her death before they actually sold the asset.
Yeah.
So then they were free and clear of that threat.
Right. So the creditor claim period is a year or 4 months from publication in the newspaper. So for a probate type situation, that's one tool we can use, extending when we open probate in order to avoid those types of claims that we may anticipate. However, with a trust, only those named in the trust are entitled to copies. So that's where that privacy comes into play.
Which brings me to another situation where I had a gentleman, 93-year-old gentleman. His wife had taken care of all the paperwork. She was a CPA. She died 5 years earlier. He didn't know where the trust documents were. And the company that had done the trust documents had been sold. And he couldn't remember the name of the new company. And that information is not public.
Yeah.
So it took a lot of searching around before we were able to uncover all the trust documents. And they hadn't been updated for 20 years. And in this particular case, the son and the son's wife were inheriting, X amount, but they had divorced.
Oh.
And so nothing had been updated. And so, again, that all happened before the last surviving spouse died.
Yeah.
So they were able to correct it. Go
Oh,
to someone
wonderful.
like you.
Very good.
And update that trust.
Yeah.
So that when he died, the ex-wife wasn't getting a portion of his estate.
Right. No, for our office actually offers free annual reviews for that reason. So we have our clients come in every year if they'd like to chat with us to learn about changes in the law and discuss maybe updating their plan if there have been changes in their circumstances as well.
Yeah, those are things that you just don't think of. You've done your plan 10 years earlier. You kind of check that off. I've got that accomplished. Yeah, as life goes on and someone divorces or more children are born.
Right.
And they're not considered in the trust.
Right.
So,
yeah. That's why we like an ongoing relationship with the clients and even the client's children if the client would like them to be involved in the process. We always tell our clients as long as the heirs have our phone number, then they'll be fine after your passing.
excellent advice. So, Nicole, thank you so much for coming and sharing this vast amount of information with us. I think that it will probably help a lot of seniors from making any possible costly mistakes. And if they need to review their will or their trust or their power of attorney or create one, how would they contact you?
Yeah, so they can call our office and ask for me. Our phone number is 303-991-3544. And again, my name is Nicole Andrzejewski. I specialize in estate planning. That's our powers of attorney, wills, and trusts, as well as probate or estate administration and trust administration.
So thank you very much, Nicole. I'm Vickie Hall, Senior Real Estate Specialist with RE/MAX Professionals, and I can be reached at 303-944-1153. Thanks.